Hello, I am Ashwini Tarur, Associate at the Center for Law and Policy Research. This is part 2 of the 4-part series on the Uniform Civil Code. Please refer to part 1 of this series for the constitutional history and debates around this issue. In this part, we will be talking about the pronouncements by the Supreme Court around Article 44 of the Constitution, which is a directive principle to the state to endeavor for a uniform civil code. The issue of a Uniform Civil Code or UCC was dormant at the Supreme Court until 1985 when the court passed a judgment in Muhammad Ahmad Khan versus Shah Banu Begum. When Khan threw his 62-year-old wife Shah Banu out, she filed a petition under section 125 of the Code of Criminal Procedure asking to be paid a monthly maintenance of 500 rupees. Her husband said he is obligated to pay her a lump sum of only 5,400 as per the Islamic law. The court held that the definition of wife in this section includes a divorced wife and Muslim women and held her to be entitled for maintenance. The court went on to say that a UCC will help national integration by removing disparate loyalties to laws which have conflicting ideologies, and that a beginning has to be made in this if the constitution is to have any meaning. In the same year, in Jordan Dingday versus S.S. Chopra, the court had to decide if a marriage could be nullified under the Indian Divorce Act on grounds of importance. The court noted the lack of uniformity between codified personal laws related to divorce, as the Hindu Marriage Act allows a marriage to be dissolved after a year of judicial separation, while the Indian Divorce Act does not. The court saw this case as a proof of, to quote the court, totally unsatisfactory state of affairs consequent on the lack of a uniform civil code. But the court left it for the Ministry of Law and Justice to take action as they deem fit. For the history behind the drafting of this article, that is Article 44, please listen to part 1 of our series. Let's fast forward 10 years, 1995. We have Sarla Mudgal versus Union of India, in which a Hindu man converted to Islam to solemnize his second marriage. The question in this case was whether the second marriage is valid without having the first marriage dissolved. The judgment saw very strong statements from the court in favor of a UCC. The court said when more than 80% of the citizens, and the court was referring to Hindus here, have already been brought under the codified personal law, there is no justification to keep in abeyance the introduction of a uniform civil code. Another interesting judgment is Pannalal Bansilal Pitti versus State of Andhra Pradesh, which came out in 1996, just a year after Sarla Mudgal. This judgment recognized that India is a pluralist society with different religious beliefs and tenets. The court said, and I quote, the directive principles of the Constitution visualize diversity and attempt to foster uniformity among people of different faiths. A uniform law, although is desirable, enactment of it in one go perhaps may be counterproductive to unity and integrity of the nation. The court was not completely against uniformity in laws, but it cautioned that it must be a gradual progressive change. In 2003, John Valamattam, a Christian priest, challenged the constitutional validity of Section 118 of the Indian Succession Act, claiming that it was discriminatory against Christians as it placed restrictions on their ability to will away land for charitable and religious purposes. A 3-judge bench struck down the provision and referred to Sarla Mudgal and said that marriage, succession, and similar matters of a secular character cannot be brought within the right to freedom of religion under Article 25. The court reiterated Sarla Mudgal and said that a UCC will help national integration by removing the contradictions based on ideologies. In 2011, in ABC versus State, the question was whether an unwed mother must notify the father of the child about her petition to be appointed as the guardian of the child. The court noted that Christian unwed mothers in India are disadvantaged when compared to their Hindu counterparts, who are the natural guardians of the children by virtue of their maternity alone. Again, the court observed that a uniform civil code remains an unaddressed constitutional expectation. In 2014, in Shabnam Hashmi versus Union of India, a case involving adoption, the court said that the Juvenile Justice Act is a small step in reaching the goal of a uniform civil code by laying down procedure for a prospective parent to adopt an eligible child. The court said that personal beliefs and faiths must be honored, but legislations cannot be stultified by personal law. The most recent judgment of Shaira Bano versus Union of India, involving an archaic practice of triple talaq, reinitiated the conversation around religion, personal law, and uniform civil code. The issue of UCC came up because one of the councils brought up the Constituent Assembly debates in his submissions and said that the intent of the Constituent Assembly was to protect personal laws of different communities by elevating their stature to that of other fundamental rights. The court concluded that this leads to the clear understanding that the Constitution requires the state to provide for a uniform civil code to remedy and assuage maladies. What is most interesting to note is that in February, the Supreme Court, in this very case, refused to hear the Uniform Civil Code issue along with the Triple Talaq issue. The bench said that the two are separate issues and said that Triple Talaq is a matter of human rights, so we will deal with it properly. So we can see that for the past 30 years, the Supreme Court has alluded to the need of a UCC, but noted that India's pluralism must be respected and mentioned the need for gender justice. Might I point out that all of these instances are obiter dicta, which is an opinion which is not essential to the decision and is not legally binding as a precedent. Nonetheless, the Supreme Court has prodded the legislature intermittently to begin efforts to draft the Uniform Civil Code. Thank you for listening to part 2 of our series on the Uniform Civil Code. Part 3 of this series covers the politics around the Uniform Civil Code. Stay tuned for part 4 of this series for our take and analysis on this issue. Visit us on www.clpr.org.in. Please visit cadindia.clpr.org.in, a website that has curated the Constitutional Assembly debates. Please visit scobserver.clpr.org.in, a website that tracks select cases before the Supreme Court. You can find us on Facebook at CLPR SC Observer and our Twitter handle is at CLPR SC Observer.